Yeah, essentially addressing that we don't have any place in the township that includes a power plant, is that what we're talking about?
No.
Page 4? Yeah. Oh, okay.
That's a different issue.
Yeah, and I kinda mixed the two together there at the end, but I'll go over it. If there's a challenge that the zoning ordinance was exclusionary, if the district exists on paper, but no area within the township is zoned to that use, this is very likely exclusionary. And an ordinance will be filed to contain de facto exclusion, or an ordinance permits a use on its face, but when applied, acts to prohibit the use through a municipality. And I cited the Tri-County landfill, and this would be the case here, where the use would be defined in the ordinance and thus permitted. However, as applied, such a district would be exclusionary, since there would not be any location within the township where such use was prohibited. So we should define and designate at the same time.
Okay. Do you wanna talk about oil and gas things now, or wait till they come up later?
I can defer till later if you like.
Thank you.
You're welcome.
Discussion on wedding barn stuff.
Okay, well, I basically jumped the gun there a second ago, but I'd like a vote up and down among the committee, members here to determine whether or not we really want, wedding barns, as a use in R2. I don't think we have clarity, I don't think we have real clarity on that as we've gone through this
Right,
process.
I think we agreed we should write it that way, so we had it.
Yeah, and then now we can decide whether we wanna include it or not, so I'll make a motion that there's a vote here, for whether or not to include, wedding barn uses in R2 designation.
Do we have a motion, do we have a second?
I'll second that.
We have a motion and second. And I guess we'll have to answer.
So a yes vote, if we vote yes, is to include it, a no vote would be to exclude it.
So a yes vote will.
Include our wedding barns in R2, and a no vote will exclude it from R2. Meaning we don't want it in R2. And again, it's just kind of the mumblings that we've had back and forth, without a lot of clarity attached to it in terms of just what we wanna do.
Discussion?
This is gonna get confusing in a minute, so let me suggest something here. I think you could get to what you wanted if somebody wanted to vote no. The easier way would just be to delete number 3. Which adds wedding barns to the list of conditional uses in R2. And that's basically what you're asking for, is do we want that, correct?
Yeah. Exactly.
And the reason that I say that, it makes my minutes clear, but to me, the answer to that depends on what else is in the ordinance.
Mm-hmm.
So, if the question is,
That's a good way of putting it.
allow them in R2
Under these
as
conditions.
we've established it, I might answer
Yeah.
differently than just,
Yeah, no, I think that's a very fair way to put it, and, I think we can look at what we have and decide whether that fits. And then we can also look at it and decide whether, it might fit, but it just doesn't seem like the right use in that jurisdiction. And I think that's really where I'm coming from.
Anybody, any other comments?
So one thing I think that needs to be, added to the ordinance, I mean, this is maybe not just because of wedding barns, but this is basically triggering it, and that is, we're gonna have outside people coming in, people from in the city. I think we need to add the, a nuisance disclaimer for agricultural or, maybe, and again, maybe we should keep out in agricultural. For, once you're in an agricultural district, you have, odor, you have noise, you have slow-moving vehicles. I think we need to add that in our ordinance, especially if we have outside people coming into the area. I think it'd be, we could put a nuisance issue, for safety of the farmer and also the supervisors.
In general for all activities.
Right.
It wouldn't necessarily have to be put in this ordinance, though.
A separate
No,
It
amendment.
could be a
that's-
separate, it's a separate consideration
It's separate.
that goes along with this kind of an ordinance.
Right, there's outside people coming in.
Yep.
They'll have a wedding and, oh man, somebody cleans the table, I smell manure. Well, you're in agriculture, that's what it's gonna do.
Is there nothing that protects agriculture already from that?
I
Yes,
thought the MPC
There's-
does,
Absolutely.
yeah.
There's some, but there certainly are townships who have the kind of thing that John suggested.
But you don't think that needs to be in here?
Not, if it's, I don't really know if it needs to be in here, but we need it in general. I think we need it in general, this is gonna bring outside people in the township, which is, I think is good. So I guess it's up to you to decide whether we need to have that in here. I mean, I don't know if we,
And we'd have to figure out where to put it, whether it goes in section 700 or whether it goes in 900 or somewhere else. But if that's a separate issue, we can docket it
right,
and take it up at the next meeting. Is that what you
we
want?
can do that, sure.
So Fred, is your motion that we vote on the question of R2 now,
Yeah,
before we work through the rest of it?
yeah. I think we got the bones of this thing. I think
Okay,
it's just a matter of tweaking it. But the fundamental question, at the end of the day, really is, do we want it there or not? Regardless of how we actually control it, I suppose, but just.
Okay. Start voting.
I got one more question, basically our two areas, are they basically, I suppose some are heavier populated than others?
there's only one R2 area.
There is only one or two.
Mhm.
Oh, that's this one.
Now, that doesn't mean other things couldn't be rezoned later, but right now there's only one.
Or,
You wanna call the roll, or we wanna do it?
Excuse me.
Normally, we just do a voice vote
Yeah.
and decide, and so the motion, if I hear it, is, shall we continue to allow, or to include wedding barns in R2 under the conditions set forth in the ordinance? Is that a fair way to put it?
Yep. Blue, I was gonna
All in
make it.
fa-
I have
all
to
in-
recuse myself.
Oh, right.
all in favor of leaving R2 in, signify by saying aye.
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 Hmm.
All opposed?
Opposed?
opposed.
Now, the
Really
neat,
don't.
the neat parliamentary thing is, if this had been posed as an amendment, a tie vote would leave it in. Because it was proposed as a separate thing, it's not clear to me what a tie vote does. Somebody can go find their copy of Robert's rules, that's why we have a solicitor.
We got our solicitor. Flip a coin?
No, I don't think that, you're gonna pass with what you have, 2-2.
I don't know, I'm, not against any wedding barns, I mean, I think that's a good idea.
Okay,
So, I have no idea what to do.
well, I think you just said
You
it
just
doesn't
heard it.
pass.
Doesn't pass.
Pass. Okay.
And the reason was you would have to have a majority,
Yeah, it's, the motion didn't have the majority to,
right, so it would take a majority to get it passed, right, I guess.
That would remove R2 from, we'll have to remove, R3.
Yeah.
Well, it's more than that, there's a bunch of places in here that talk about R2. Yeah. Okay,
Okay. So this will need to be, cleaned up and until, as we vote on,
could I ask the solicitor a question?
sure.
Trying to sneak out. If the solicitor, you're the solicitor, the supervisors, and I'm not predicting anything, I'm just asking so everyone's clear, wanted these in R2, they could propose that amendment, correct?
essentially, you're a recommending body, you're not a
Right.
you're not a binding
But
body.
if they made that recommendation, would it have to come back to us?
I think your minutes would clearly reflect that it did not have the support to pass, and your recommendation is what's reflected in your motion. Obviously, the supervisors are not bound by your recommendation.
Well, what concerns me is we had included in here a number of things particular to having wedding barns in R2 that now would have to go away. I mean, that's just the reality of that motion if it doesn't pass. And so would the supervisors be able to just pick that up? Or would it have to come back here so we could put such things in if they thought they wanted it in R2?
Essentially, I have the amendment or document as written in its current form, and whatever may come by further recommendation, I already have the original version with the conditions and
Okay,
requirements in it.
so we're all agreed by common consent that anything dealing with R2 comes out as a consequence of the previous motion.
Yeah. And obviously we recognize that the supervisors can put it right back in if
Right.
they want.
But I just didn't want us to lose that language.
Yep.
But if he's not going to, that's fine.
Yep.
Okay. What do we want to do with the suggestions the solicitor had?
Regarding,
Wedding barns. That's what we're still on. I mean, do you wanna work through them? Do you want me to redraft them and just work it all in and bring it back next time?
yeah, why don't you do that?
We had some suggestions for additional stuff on barn.
Yeah, that's the one that troubles me, is what's a good definition for a barn. I doubt blacks, I think I even looked in blacks, I don't think it defines barn. I actually used a dictionary definition. Okay,
I can run a case law search for you on, Lexis to see if it's defined anywhere in other, legislation and forward it to you.
and so then we'll take this up again in November.
Okay.
Do I need to send it to the solicitor again before our meeting, or are we comfortable enough? Okay,
Good enough.
okay.
I guess we're on to, light industrial district,
Yeah, let's table that.
table that one?
Yeah.
Yeah, we gotta think about where it's gonna be, and
Oh,
anybody object to tabling that one? No?
No objection.
All right, we'll pass on that one. Okay. Oil and gas amendments, next.
And this is where we said we would have the comments. It would probably be useful to remind people that we changed our procedures for taking comments. That we reduced the speaking limit from 5 minutes to 4 minutes. That what happens at the time of public comment can only be on issues on the agenda. And any others can come up at a time at the end of the meeting if the chair deems time allows.
Yeah, I'm trying.
And do we wanna hear from the public and then the solicitor?
yeah,
Okay,
I would say so.
yeah.
Okay.
okey-dokey.
Pick one. Pick one. Very well.
So the only thing you have listed on here for oil and gas is amendments dealing with pipelines. Well, I guess I'm not
but-
clear with,
I should, sorry,
Okay.
this, I should have reported this as part of my report. Unless something happened to the agenda I send, it said referral from the supervisors. And the
Right.
supervisors referred the oil and gas amendment back to us to, consider in light of the recent Supreme Court decision.
okay, so we can talk about that.
Just
Okay.
for a second, point of clarification, they referred, the supervisors referred back to us simply the court's most recent decision. I'm not sure it was also referred back to us to reconsider our oil and gas ordinance.
Yeah, that's the point.
Attached, please find a memorandum concerning the recent Supreme Court decision on Act 13 of Robinson Township versus Commonwealth 2016. Additionally, attached, please find a copy of the decision, a recent article addressing the decision. The board would like the planning commission to review the Robinson Township ruling as it pertains to the Wilmington Township oil and gas ordinance.
Okay.
Please do not hesitate to contact me.
Okay, thank you.
And I should have recorded that, under correspondence.
Yeah,
Forgot
okay.
that we're not doing that.
Okay, I just wanted to be clear before I started my comments.
Who's timing?
I guess I
I
will.
don't want fights over who got more time than whom. Sorry.
Sorry, okay.
Okay,
The
so.
first time there didn't count.
Okay,
All right.
so, first thing, I just wanted to comment on, John, about the Right to Farm Act. In 1982, Pennsylvania passed the Right to Farm Act. And just to give you a brief overlay, it says accordingly, in 82, the Pennsylvania legislature enacted the Right to Farm Act with the express purpose of limiting the circumstances under which agricultural operations may be subject matter of nuisance suits and ordinances. So it's protected. Farming is protected in Pennsylvania.
Okay.
I became very familiar with that when someone started to say that the 2014 ordinance was so onerous that it could lead to ordinances that would prevent manure being spread on property. And I knew that that was completely false. It would never happen. So I have a couple handouts. One is just an overview of the recent decisions. I don't think I did that. Sorry. I think I was originally gonna give this to the supervisors. So, just for you to read, it's just kind of an overview of what decisions were made, what that recent decision in Act 13 meant. There's also a copy of the Pittsburgh Post-Gazette article, which goes through a little bit more of the decision with some of the comments from the attorneys involved in the case.
Give
So,
Jay one of these.
yeah, that one I was
Oh,
short
you ran
on.
out, okay.
So just again, something for you to read about it. And then also in our local newspaper, more information on the decision and more interviews.
This is not what you sent, by email?
I didn't send you.
I saw from email came from you. It was on the on the, it was on something, never mind, it was something else.
Okay.
Yeah.
So, I'm glad Mr. Pratt is here because, he was quoted in here as saying,
You don't have to
That-
quote me again.
okay,
It's in the article.
Well-
I know what I said.
for the audience, he added that the decision obligates the industry and our local community to work together in promoting Pennsylvania economic interests as well as indispensable rights guaranteed under the Pennsylvania Constitution and the U.S. Constitution. So I have a question, where in that decision did it talk about the economic interests, that we have to balance that?
I'm not here to answer your questions.
Okay.
On the,
So my group was also quoted in here, and our position hasn't changed. Since July, when I sent up a postcard, and that was on my own, I sent a postcard out to the community to tell them about the first hearing to discuss the oil and gas ordinance. And at that time, I said that unconventional gas drilling is an industrial process, and it belongs in industrial zones. I've never changed my position on it, and now a large group of us in the community as well support that position. We have a petition with over 140 signatures on it of residents who also feel the same. This is highly industrial, and it needs to be in an industrial zone. If we don't have enough room in our current industrial zones, just as we're considering for Elwood City, especially steel, to expand, we can create a larger industrial zone. That's all.
okay, thank you.
So, just, I can ask questions,
Yeah.
right? So just so I'm clear, hypothetically, if someone north of Oland within the township wanted to be able to drill and have a compressor station, you would advocate that the proper course would be to seek to have that property rezoned industrial, which would allow all industrial uses there. Not just oil and gas, it would allow steel mills, batch plants, everything.
Correct, but with any kind of zoning change, there should be a well thought out plan. And another thing we've recommended several times was to hire a land use planner to help us take a look at the entire community and where these areas, where this kind of industry, where would it be appropriate for our current layout?
Thank you.
Anybody else have any questions? Okay. So, I'll do with hers. I've got it right here. I'll say who's next one. Yeah, I did.
Okay.
Karen Wallace.
Karen Wallace, Township resident. I've never asked for fracking to be banned. I've asked for reasonable safeguards to be put in place to protect the health and safety of our citizens. In the past, I've heard Mr. Solomon, the former township solicitor, explain first that the township had the right to put safeguards in place and then later change his legal opinion. And now the recent court rulings say that municipalities have the right to regulate unconventional drilling activities. The current solicitor, Mr. Parada, was quoted in the Newcastle News, the ruling marks a victory for municipalities across Pennsylvania who, as a result of the decision, have regained autonomy in the review process for local ordinances concerning oil and gas development. He added, the decision obligates the industry and our local community to work together in promoting Pennsylvania's economic interests, as well as indispensable rights guaranteed under the Pennsylvania and United States constitutions. A balance is required. Pennsylvania Constitution, Article 1, Section 27 states, and the courts reaffirm, the people have a right to clean air, pure water, and to the preservation of the natural, scenic, historic, and aesthetic values of the environment. Pennsylvania's public natural resources are the common property of all the people, including generations yet to come. As a trustee of these resources, the Commonwealth shall preserve and maintain them for the benefit of all the people. Things have changed since the proposed ordinance concerning unconventional drilling was written. It's time to take a look at what should be done to protect the safety and health of Wilmington Township residents. You can do it. You're the board that writes, and you should do this. It comes down to a balance between health and wealth. It isn't banning fracking, which would be the very best thing for health and safety, but this would not at this time be legal or consider the rights of leaseholders. And it isn't letting the fracking industry influence municipal authorities to write ordinances in the industry's favor so that they can make as much money as possible without regard for the health and safety of residents. Moving forward, the oil and gas ordinance should allow fracking only in industrial zones. It is an industrial process. Require compressor stations to be enclosed in a soundproof building with strict noise and air quality monitoring. Require comprehensive testing of air, water, and soil, and return to the setback requirements of the 2014 ordinance. I have a copy of the League of Women Voters of Pennsylvania Shale Gas Extraction and Public Health Resource Guide for each of you. I hope you will read it all, and especially look at pages 9, 10, and 11, Health Impacts, Selected Toxins Associated with Hydraulic Fracking. You've been working on the oil and gas ordinance for a while, I understand that. During that time, what is legal for you to do has changed. You have some power again. Wealth versus health. The balance is in your hands.
Thank you.
Anybody have any questions for Ms. Hall? What do you think of when you think industrial? What do you consider to be industrial? Just a question.
I have no prepared definition of industrial.
How do you know that it's an industrial process?
Can I say, how do you know it isn't?
Okay.
It requires, a large amount of land, it's noisy, it's hazardous, produces toxins,
Okay. Just wondering what definition we're thinking
No, I
of.
wouldn't call that a definition by any means. I mean, I would,
Okay.
basically,
I guess when
I
I
mean,
think
if you look at a, website of legal counsel for the oil gas, and it refers to it as an industry. So if their own attorneys refer to it as the oil and gas industry, I guess that would be a pretty good indication that it is indeed an industry.
But we refer to agriculture as
Yeah.
an industry.
agriculture is the biggest industry in America.
I mean, that,
Well, then what is industry? Any kind of human endeavor?
I kind of think of industry as being where you take raw materials and do something with them to produce some other useful material that we want, which is basically precisely what agriculture does.
Mm-hmm.
not entirely sure that agriculture really wouldn't be considered a industrial area.
Okay. So, I guess,
And that's not
are you,
really
are
defined
you
that way,
saying
but-
unconventional drilling, in your opinion, is not industrial?
Well, are they taking, raw materials and turning them into a usable, something that we use?
Well-
Or are they just, extracting something and, sending it
So-
on? I'm not, I don't know the answer to this.
Coal mining is not an industry. They're taking raw materials out of the ground, but they're not producing anything right there. To me, it would be
I'm
the
not quite
same
sure what a
sort of thing.
definition of industry is.
Right,
Yeah.
but if like coal mining is an industry, then I would see unconventional drilling as an industry, it's extracting. Does something have to be produced right at the site in order for it to be an industry?
Well, I was kind of asking,
But industry and industrial aren't the same thing by most zoning definitions, as I understand them.
Pardon me?
Industry and industrial aren't the same thing.
Okay,
I mean, industry is any organized activity. That's different from what's industrial. I mean, again, we do talk about the agriculture industry all the time, but I assume we wouldn't say that agriculture has to be in an industrial area.
just asking questions there.
Yep.
Okay, thank you. Who's next here?
Oh, you have.
I have the list spread out here, let's see what do we got here. Wayne Lucas.
This is the same thing.
This is the same thing that we
Same as-
transmitted by email yesterday, I just didn't know whether the members had, hard copies.
Okay.
And I'll be brief, I think it's fairly self-explanatory. We just have, three main concerns about the ordinance, and I do wanna comment briefly on the Robinson Township case. With respect to the setbacks, there are a number of them, as you know. A lot of them apply to oil and gas wells. They're fairly restrictive. I think we've shown that the amount of land that's available is probably 20% or less. Our concern was when the board added the 500-foot setback for compressor stations from the property line. We did some mapping on that, and when you combine all the restrictions, you see you just have a couple spots left in the township, less than roughly 1%, and that's not taking into account whether those tracts are developable because of terrain, wetlands that we don't know about, whether you can procure them. And the concern is if you totally exclude, or almost exclude, a compressor station, that has a ripple effect of not being able to get the gas out of the township. We'd asked that both the planning commission and the board of supervisors take a closer look at that. One thing I would like to point out, when you combine all those requirements, that 1% is a couple scattered spots in the A1 district. There's no land available in the industrial district with those setback requirements. So, I mean, it's not just the 500, it's when you combine the 750 from buildings and other things.
Excuse me. Number one, Mr. Chairman, could you ask for order? If we're going to say that the public ought to be informing us, we all ought to be willing to listen to each other, and there's an awful lot of noise. He's up front and I'm having trouble hearing.
Let's keep quiet and let our speakers speak.
May I pose a question at this point, just so I'm sure I understand it? On page 2 of what you said, you lay out all the things that limit where compressor central stations can go. And you include in that perennial streams and wetlands. Is it our obligation under the zoning ordinance, as you understand it, to make sure that topography doesn't get in your way?
Oh, I think as a practical matter, if you impose a set of restrictions that by the time you're all done, it's not developable for any number of reasons, and not only would it be topography as it relates to wetlands, it would include DEP or Army Corps limitations as it relates to wetlands too.
I understand that, but my question is, it can't be the township's fault if certain sites aren't developable because of topography.
But if the township overlays a whole bunch of restrictions that only limit you to a spot, for example,
I'm
from
not
Pittsburgh
debating
area.
that, I'm not debating that.
Yeah.
What I wanna know is, I'm right in reading that your map is including where streams are, where wetlands are, that exclude things.
Known streams and wetlands. The thing about
Yeah,
wetlands
I
is that,
understand.
you have to
But
study a
your
specific
map
site.
is including all of that, it's not just the 500-foot setback.
Oh, correct, it's all the requirements, yes, absolutely. And as we note in our memo, and it was the same, comment your solicitor made on other issues, is, there's a risk to the township if you effectively exclude a use altogether. Someone's typically entitled to what's called site-specific relief if they challenge it and succeed, so it's not advisable, and I say this as a municipal solicitor too, to be so restrictive that you subject yourself to an exclusionary zoning challenge, because then you've lost all control. Secondly,
Again, let me follow up, is that okay?
yes,
And my printer ran out of paper, and so I don't have the language in front of me, but my memory is that with those setbacks, we said that if the adjacent property owner was willing to waive them, as long as that was recorded, that was okay. And you're saying that's still too restrictive?
well, it puts any, whether it's through this use or anything else, it puts you at the mercy of what the adjacent property owner, and there's case law at the Supreme Court level that says you basically can't, while waivers are great to have, that doesn't shield you from, for example, exclusionary zoning challenge. And I don't mean to get too down in the weeds here. I think our primary comment is more, the comment was made that it needs to be a reasonable balance, and this seems to have shrunk it all down too far again.
But the flip side is, you say in here you wanna work with this, I'm not sure I see where the working with this is.
We'd ask that you take a closer look, particularly at that 500-foot setback, because when you take a track, it's what, when you have a square piece of property and you start measuring 500 feet back the whole way around, all of a sudden you're talking a very significant large tract before you even decide, before you can even determine whether something in the middle of that is developable. It's the distance from existing buildings, a little bit different situation, and 750 feet, so it's pretty substantial.
But again, with respect, if you're just saying, hey, 500 feet doesn't work for us, you're not giving us a number that does work for you, I'm trying to figure out how you're working with us here.
Well, I think the
So
number.
we come up with another number and you're back saying, no, that's still too restrictive.
Well, the old
Frankly,
number
this
was
map-
200 feet.
This map looks just like the map that you showed us under the 2014 ordinance.
No, well, the 2014 ordinance, there was nothing, okay?
Okay, where did you're the one that suggested the 500 feet, so where did that come from?
I understand, it was an attempt to balance what we had
Right, so
between
it
the two
was like,
ordinances.
we pulled it out of the air. So
Not-
the consequence of
Not
what,
denying that.
the consequence of that is evident in the map.
Point of order, Mr. Chairman.
Yes, go ahead.
I think what Mr. Nykerk was referring to was a written waiver filed with the recorder of Lawrence County. And I don't wanna cut into Mr. Lucas's time, but this 500 feet that we're talking and debating about now in October, correct me if I'm wrong, that was on the books since March.
Yes.
And Hillcorp and Chevron had an opportunity to come here and pretty much work through that particular amendment and ordinance that was before the planning commission, and I think the commission gave them a significant amount of time to work through their comments. And I don't ever recall any objection being made in March to 500 feet.
What happened was that amendment was added at the last meeting.
Just so it's real clear.
And
I'm assuming when we're asking them questions, that's not counting
No,
against
that
this
doesn't,
time.
I'm not sure
I
if I
just
can
wanted
keep
everybody
track.
to be clear
I'm
on
not
that.
sure I can keep
Just
track
like
of that, but.
It was past Kerry's time, and we asked questions after.
we did express our concern about it when that motion was made to amend that provision, but I think the memo is clear on what our concern is there. It used to be 200 feet, and that we'd ask that the township could reconsider that. Secondly, there was not, as part of what you forward along as part of the ordinance, but as a side, which the majority of the planning commission didn't recommend, were some water and testing requirements. We think the case law on that's pretty clear based on some cases under the old Oil and Gas Act, which the recent Robinson Township decision seemed to reinforce that those kind of water testing issues are solely within DEP's domain. We also question whether the township, with its staffing, I mean, you're talking major, serious technical experts you would have to have available. The third issue deals with the enclosure of compressors. We understand that why there's a desire to do that, but you're really addressing that three ways. You're saying have a big setback, you're saying limit it to 60 decibels, and you're saying enclose. If the concern is the amount of noise, if an operator can show because of distance or whatever, a mounding, that you can meet the decibel requirement, enclosing a building may be unnecessary. Recently, the last point deals with the Robinson Township decision. The big issue was 2.5 years ago when the Supreme Court struck two of the sections that limited what local governments could do, but it kept intact section 3302, which was basically the same preemption provision under the old Oil and Gas Act. That's the one with the range resources case dealing with water testing and the like. Basically, you do have authority, there's no doubt about it. You can regulate the where within reason, but you can't regulate the how. So we don't view the recent Supreme Court decision as having much of a material impact. The ship sailed really and conferred back to you a lot of authority in December of 2013. The current case doesn't really add much more to that.
Okay.
All right, okay, thank you.
I have no idea how to keep track of time while we're talking and asking questions,
Stop the
but
clock when we ask a question, start
I
it when
don't have
you're
a
done
stop,
answering.
I don't have a stopwatch.
That's why you're a physicist.
Okay. Warren,
I'm a little confused here. I thought I was gonna pass because I thought you said it had to be relevant to the Supreme Court. But since Mr. Lucas brought up about setbacks and waivers, I feel
I'm not happy, but I think they referred the whole ordinance back to listen. I think, my opinion is you can say whatever you want about the ordinance,
Okay,
as long as you can
thank
say it
you.
in 4 minutes.
Thank you. Do you want this now, or I have a copy for each of you?
okay.
I want to speak about the waivers. In 5 different sections, this is the next to last paragraph, so I can't do this whole thing in 4 minutes, so. No, on the first page, I'm sorry. Next to last paragraph on the first page. In 5 different sections of Ordinance 1, where maximum protection to the people's health and general welfare is crucial, in my opinion, there's the possibility of a waiver being given to the oil and gas company. And then I have the 5 sections listed there. But in each of the first 4, it says all the gas and oil company needs is the signature of the property owner of an adjoining property. And it says about how you can cut it back from 1,000 feet to no less than 200 in one instance in that. But then on the 4th paragraph, 2nd page, that's where I'm going next. The written waiver for each of these 4 is recorded with the Lawrence County Register and recorded. Neighbors other than the adjoining property owner are not involved, and neither are the planning commissioners, township supervisors, nor the zoning hearing board, where a public hearing may take place. Nearby neighbors might not know about the waiver until the noise is loud and constant, and or the well or compressor station encroaches upon their property or water. Then it's too late for any preventative measures. Also, what's to prevent the oil and gas company from offering the adjoining property owner a dollar amount to sign the waiver? The fifth waiver deals with compressor stations.
Hold
on a second.
I'm sorry?
I have a question.
Sure.
So, is it your opinion that neighbor X, under the current proposal, that neighbor X could waive the setbacks of neighbor Y?
No, the neighbor X will waive the setbacks to its property line. But in doing that, it could also then affect the setback distance to neighbor Y. Because it doesn't say in here it needs neighbor Y.
Right, but you still would have to meet the setbacks of all the other properties.
It doesn't say that. The ordinance does not specify
We
that.
can ask the solicitor about that, because I think that would be obvious, but maybe not. Okay, thank you.
Waiver 5. Compressor stations are to be enclosed in a sound muffling building equipped with a system of filters which filter the emissions associated with the compressors, etc. A waiver of these may be granted only if the applicant or operator can demonstrate that an alternative will provide protection of the health, safety, and welfare of the citizens that is equal to or better than that mandated by this provision. I find that really hard to understand because the health of the individuals in the community is an ongoing thing. It's time, there's no time period. How can you demonstrate something in a finite time period is going to be equal to something that's goes over an infinite time period? Cancer is showing up in 10 years. If they demonstrate this in what, 1 month, they get a waiver? I don't understand that one at all. So what I'm asking is, that you look at these waivers again, and I find it ironic, just like we were doing this wedding barn, that the people of the community have to go through a variance process, go to the zoning board or you, where an oil and gas company can just get a waiver. Thank you.
Thank you.